So Nadja, you talked a little bit about needing certainty in some situations, but also wanting flexibility. I mean, can you say a little bit more about that? Why would we want more certainty, and why flexibility, and how do you reconcile those two things?
So that's a great question. When we think of mediation, we think about this flexible process, right? And then we're really thinking about the internal mediation process. We're thinking about what happens in the room. And I absolutely agree, and I think most lawmakers, regulatory actors in the world would agree, that needs to be flexible. And what you'll find is most of the rules about how many steps are there in the mediation process, and whether or not you have a private confidential meetings with one party and the mediator, those sorts of things about what happens in the room are usually regulated in the agreement to mediate and or by institutional rules. They are not usually found in legislation because that needs to be flexible, right? On the other hand, if you're a person in mediation, either a lawyer, a party, mediator, or even a translator or somebody else in mediation, an expert, you, I think, want to have a fairly clear idea about what your rights and obligations are. For example, what are my rights and obligations in relation to confidentiality, right? When I leave the mediation, who's allowed to say what, if anything, about what happened in the mediation room? And those sorts of things need to be certain, they need to be clear. I think we're in a lot of trouble if every time you had a different mediation and you could change those rules in the agreement to mediate, right? Because then a couple of things would happen. People would forget, particularly repeat actors like lawyers and mediators, could very easily forget, what are the rules of this mediation? You could easily miss something. And also, it's very hard then to build a body of jurisprudence, a body of case law, for example, around how you interpret that, particularly if each mediation has a different rule about what people's rights and obligations are. Now, I'm not saying it always has to be the same. There is room for some flexibility. For example, there are some mediations where you might want limited confidentiality. For example, if you're dealing with a public policy issue, you might even want parts of that mediation to be open, right? So while there are certainly exceptions, I think there's a lot to be said for having some very clear rules about people's rights and obligations. For example, what evidence from a mediation can be put before a court of law. If, for example, parties reach an agreement, but there's subsequently a disagreement about what they agreed upon.
Yeah.
Now, so this isn't about necessarily what happens in the room. This is about what happens when the mediation process interfaces with the legal system.
Yeah.
And that's when you need clarity, you need predictability, you need certainty. All those things then become really important. So that's one example. So earlier I said you can't treat mediation law as like one big lump, right? You've got to differentiate the different aspects of mediation law.
Okay.